the defense bears the burden of proving that when they committed this act, it was not done voluntarily. A criminal act is generally a physical movement, and that criminal act is considered voluntary when it is in some way willed by the actor. The act could be voluntary even if it is a result of a habit or is inadvertent. As long as the actor had the option of acting differently, then the act will be considered voluntary. Whether the action is a force of habit or a wholly deliberate act is important when it comes to the gradations of offenses, but the actus reus requirement is satisfied in either case. So your book gave a very good example. Let's say Larry lights a cigarette. He then falls asleep. He drops the cigarette, sets the house on fire, and manages to wake up and escape before the fire consumes the house and kills his wife. As an alternative, let's say, let's say Larry went into his wife's room while she was asleep, poured gasoline around the bed, lit a cigarette, and then set the room ablaze, killing his wife. Clearly, his actions in both scenarios were voluntary. He had the option of not lighting the cigarette in the first situation, for example, but it would be very unreasonable to treat both acts in the same manner because the mens rea element is present in one instance and it's not present in the other instance. So we'll get to the discussion of mens rea shortly. Or I believe that may be next. Oh no, it's not next. Okay, so we just talked about actus reus. I just said that, and your book also says that there must be an act. You must complete an act in order to satisfy the actus reus, which is the first element of committing a crime. But there are some situations where an inaction or an omission will constitute an act that can satisfy actus reus. An omission is a failure to act. Certain omissions can satisfy, certain omissions can satisfy the actus reus element of criminal liability as well. I just said that. The general rule is that, with a few exceptions, no person has a duty to act in a manner that prevents injury or loss of life to another. Okay, there are no Good Samaritan laws. You are not required to act. You're not required to act unless one of these situations here on this slide apply. And an example of that is in the case People versus Beardsley, which your case talks about in it's a case that is mentioned in your book, rather. That's what I meant to say. That case deals with a man who failed to come to the aid of his mistress, who took a lethal dose of poison and died. He was not liable for her death because he was not obligated to act in any way to save her. So then the question becomes, when can an omission satisfy the actus reus requirement? And the answer to that is there are 7 specific situations where an omission can satisfy the actus reus requirement. Number 1, a relationship. When there is a status relationship between 2 parties, an omission can lead to criminal liability. For example, a woman who knew her children's father was abusing them and failed to act was guilty of child abuse by her omission because of the relationship, the mother-child relationship. She had a duty to act. Okay, then there is statute. Many states have laws that require certain officials to report actions such as child abuse. Failure to report can lead to criminal liability by omission. And those are the kinds of situation. Well, we have an example here in your book. If Scott observes David collapse and stop breathing, attempts to perform CPR, and ends up doing more harm than good, killing David, then a Good Samaritan law would protect Scott from perhaps being sued by David's surviving family members. And then there is another example, whereas, let's say, we have a teacher who is by statute required to report abuse or suspected abuse, and she fails to do so, and then something happens to this child because the child was being abused, there could be some criminal liability for that teacher who failed to comply with the statute, which required her to report signs of suspected abuse. Now, I just want to touch on this Good Samaritan law example that I just did with the CPR example, because earlier I said that there are no Good Samaritan laws, which is the case. You are not required to act to save anyone, which was highlighted in the case mentioned in your book, People versus Beardsley. He didn't have to act to help his mistress who took that lethal dose of poison. He didn't help her. He was not held liable because there are no Good Samaritan laws. But then your book says that the Good Samaritan law would protect Scott from perhaps being sued. I know that that language is confusing, but try to differentiate when I say that there's no Good Samaritan laws requiring you to act versus an individual who sees someone collapses, tries to perform CPR as a Good Samaritan, and he ends up doing more harm than good, thus killing the person he was trying to help. Then a Good Samaritan law would protect him from possibly being sued. There is a difference there. I just don't want there to be any confusion with respect to the Good Samaritan laws. Okay. Contract number 3. If a contract sets up a special relationship between two parties and that contract is breached, criminal liability is possible. For example, if someone who is contractually obligated to care for a physically disabled person fails to do so, a crime may occur as a result of the inaction. 4. Voluntary assumption of care. If a person voluntarily assumes care of another person without a contract, that person may be held liable for failure to act. There's an example in your book in People versus Oliver. I won't go through that example. You can read it on your own. You should have read it by now because these were the readings that were assigned to you for week 1. Number 5, creation of peril. This is a very good one. If George pushes Gary, who cannot swim, into a lake, Gary struggles and cries out for help, and George fails to assist, George can be guilty of a crime. Compare that to if George just happens to be walking by the lake and sees Gary in there struggling, drowning because Gary can't swim, and George refuses to help Gary and just wants to stand there and watch him drown, and that's what he does, George will not be liable for Gary's death because, like I said before, there are no Good Samaritan laws that require you to act to help another person. The law does not require you to be a Good Samaritan. But if you create the peril, if you are the one that pushed Gary into the lake, then your inaction of not helping him could result in criminal liability. Then there's number 6, duty to control the conduct of another. Assume that Larry, a business owner, knows that his delivery driver, Rick, is a reckless driver. Rick slams his delivery truck into a small car and kills the driver. Larry, through his omission, his failure to do anything about Rick's driving, may result in criminal penalties. Or Larry may be held criminally liable. And then 7, landowner duty. The owner of, say, a nightclub is required to perform certain functions, such as ensure an adequate number of emergency exits. Failure to do so could lead to criminal liability in the event that a fire occurs and one or more patrons die or are injured. So those are the situations where if you don't act, it can still satisfy the actus reus requirement. Okay, now we've touched on actus reus, the act element of a crime, and we've just finished talking about omissions or failing to act in situations that could result in criminal liability. Now we will address mens rea, which is a guilty mind. Mens rea is the second critical component of criminal liability. With few exceptions, a person cannot be held criminally liable unless there was some degree of intention on that person's part to commit the crime. Even the defendant's simple knowledge that what he or she did was morally wrong can suffice some of the time to meet this requirement. There are many levels of intent, okay? And there are many ways that one can establish or prove that the mens rea element has been satisfied. Intent is perhaps the most straightforward conception of mens rea. A person who intends to commit a crime should be the one who is liable for it. When the consequences of a person's actions are desired, this is known as direct intent. In other words, if you do something that you know will result in a specific or a particular consequence, and that is your desire, that's what you want to happen, you want that consequence to occur, then there's the direct intent for that. Okay. It's important to point out that there is general intent crimes and specific intent crimes. General intent crimes are those offenses that require only the intent to commit the actus reus of the crime without an additional mens rea component. General intent is doing an act prohibited by law, such as the crime of battery. Okay? In a specific intent crime, however, the defendant must have the intent to commit an act to achieve a specific criminal result. Common law burglary, which is discussed in more detail in a later chapter, is a classic example of a specific intent crime. In order to be guilty of burglary, the defendant must break and enter into the dwelling of another in the nighttime with the intent to commit a felony inside. The additional mens rea component requiring the intent to commit a felony inside distinguishes burglary as a specific intent crime. With battery being a general intent crime, you don't necessarily envision a specific consequence. You know, you commit a battery against someone, you hit them, it results in a harmful or offensive touching. It's a battery. But the more specific crime of burglary, it requires a specific intent, as the definition implies, with the intent to commit a felony inside, whereas battery just requires you to commit the act We're not concerned with the result. We just want to know that you